All rise. Appeal in the matter of Cuadrilla Bowland Ltd and others, and Lawrie and others. Yes, it's good.
Please, your lordships, I appear together with Mr. Brigden and Mr. Wagner on behalf of Miss Lawrie, Mr. Walsh and Mr. Wilson, who are sitting behind. And Mr. Roscoe represents the respondents, and if I can adopt the terminology of Cuadrilla, although he's representing Cuadrilla and 9 others, and similarly, although we are within a skeleton A 3 to 5, if I can adopt the terminology of appellants.
That all sounds very sensible.
There has been some correspondence and late lodging of bundles, for which we do apologise, but would it assist if we perhaps consider where we are going with the various applications at this stage?
Yes, I think we've worked out most of it, but I think it would be sensible all the same. Yeah.
The application as it came before the court was for permission to appeal the variation order, which is on the 3rd of September 2019, and it was a variation from an order on the 18th of July 2018. That position has changed in that Cuadrilla on the 19th of November sought to discharge the clauses that the appeal was focusing on, particularly clauses 4 and 7.
Yep.
And after some consideration on Friday, we, considering the guidance from the Court of Appeal, considered that we could be criticised for it being academic, and with costs as well, always being a factor in litigation of this type, we therefore communicated with the court that we would withdraw that permission. In effect, that application for the permission, because in effect, the result is that the remedy that the appellants are seeking has been achieved, but without the appeal actually being heard.
Yep.
And
but in any event, the bottom line for us, I understand the thinking, but the bottom line for us is that the application for permission to appeal is withdrawn, and therefore it's not on the agenda for today.
It is withdrawn. It's not on the agenda, and if I can add, to be fair to the respondents, that they were asked to communicate their reason, and they communicated referring to what's set out in our chronology, which is...
Hang on, sorry, the respondent was asked to set out their reason for what?
For applying for discharging.
Yes, but we've seen that. Do we need to know that?
Just for completeness, I would wish to draw the court's attention to the fact that, and it does come into, in fact, to later submissions, that the government announced a moratorium on fracking on the 2nd of November 2019, and we set that out at the appellant's chronology, which is page 1.
Well, we've seen that, and we've seen the press release and so on. A report of the press release. Yes.
I'm grateful. And so the appeal as it now stands is the appeal concerning the committal, which breaks into 2 parts. It breaks into an appeal concerning the liability finding by His Honour Judge Pelling QC, and also the appeal against the sanctions imposed.
I wasn't sure whether you were appealing the liability finding. I mean, you don't challenge any of the findings of fact, do you?
We're not challenging the finding of the breaching. We're finding we're challenging the committal.
Well,
so
that's not the liability actually,
yes.
is it?
So looking at the liability judgment, but challenging the committal, quite right. And there's also an application for permission to appeal a cost order, which was awarded against the appellants, and it was awarded after the combined variation hearing and sanction hearing on the 3rd of September. There subsequently was correspondence whereby the judge allowed consideration in order to look into varying that particular costs order, he then ruled on the 25th of November that the costs order was to remain as he had originally ordered. That is a supplementary bundle which only arrived lately. The arguments, and it includes supplementary authorities. The arguments are very similar to those which the written submissions were submitted by both the appellants and also the respondents, and they are very similar arguments. However, I understand the respondent's position is they consider they don't have time to deal with that, but perhaps if we could put that to one side and come back to it.
Sorry, let's be clear about this. You haven't got permission to appeal. They have no locus on the permission to appeal. So why would they? What do they need time for? It's not listed.
It's not listed.
On the front of the court at all.
It's not.
But you're basically, were you expecting us to deal with it on a rolled up basis?
On a rolled up basis, in that costs are going to be considered in any event. And so on a rolled up basis.
Well, why are costs to be considered in any event? We won't be considering the costs unless we give an instantaneous decision. But if we reserve, costs will be decided on some later occasion.
They will be decided at a later occasion. So whether.
Well, what are you asking us to do?
We are ready to argue on permission on.
Heard by all three of us today or tomorrow. Is that what you're asking?
Yes.
And on a rolled up basis?
On a rolled up basis.
I see.
Without any prior opportunity to read the papers.
Well, if that is the position.
Well, it is the position
Yes.
when you provide them at 5 o'clock the night before the hearing.
Yes. In that situation, no. We sought to try and expedite it, simply to dovetail.
No, I can see. I do see. If it was doable, I can see the attraction in doing it while you all know the background and so forth. But we can't be bounced into doing something that we can't do fairly.
Yes.
And I suggest we park this at the moment. When I see what we're doing, I at least will have a look at the application, perhaps over lunch, which I haven't had a chance to do.
Yes.
If it all turned on some narrow point on which we could make a ruling, and which Mr. Roscoe was in a position to deal with, then we might be tempted down that route. But at the moment, it's not on the agenda.
Yes. Well, I'm grateful for that indication for hearing me on that. If I can move then to the substantive, the appellant's skeleton argument is at tab 4 of the core bundle. The respondent skeleton is at tab 5. And
Yes, sorry, I've had various versions of your skeleton.
there's an updated, it's titled the updated skeleton argument, dated the 27th.
Yes, I've got that loose. Let me just see if you have it first. Yeah, there's the one on the 27th.
Yes, 27th.
25 pages? Well, there's a surprise. Yeah, okay, I've got it.
And the orders, the relevant orders, I'm going to be referring to the liability judgment, which is at tab 8,
Yep.
which is 28th of June. The committal order, which is at.
Yes, but that literally came in yesterday, I think. So rather unhelpfully under a compliment slip from our chambers telling us to put it to the authorities bundle. So we were clever enough to work out where it belonged. Yep.
The judgment on the variation, which also includes the sanction, which is at tab 10, and that's on the 3rd of September. The chronology, I've already referred to in part, tab 12A. However, I've been informed, literally as I was coming to court, that there are some amendments that the respondents will be seeking to that order at
When
tab
you say amendments,
28.
across purposes, I mean, it's surely a matter of record what the amended order is, and we've just getting a copy of it.
Yes, it's not sealed as yet. The varied order.
Well,
Does it matter? Given that we're not dealing with the variation.
For these purposes, we don't consider that it does matter. I'm simply flagging up that there are going to be some apparent...
we're not dealing with the varied order at all, are we? Because the order that the breach was of the early order, original order, and no issue arises as to the varied order.
It doesn't arise. Whether it comes into context that ultimately, when you're looking at sanction, that also this is a case where those particular clauses were subsequently discharged.
Well, let's see how we.
But that's where it is.
So at tab 20, we've got the order heard, whenever it was. But this in turn is overtaken by last week's application to discharge paragraphs 4 and 7.
Yes,
Is that right? And
yes.
I find it very odd indeed that an
It's-
order which should have resulted from a hearing in early submissions on some aspects, I think, but it seems a very odd state of affairs.
It is, and we had suggested where there was submissions on costs that be separated in order not to hold up sealing the order.
Yes, you did.
But it makes it complicated and also complicated.
To start at page 15, no, page 12 of the bundle. They cover, of course, both the varied appeal and the committal appeal.
Yes.
But nevertheless, they run to 15 pages. You're in the clear here because you didn't draft them, but that is not helpful to the court. Grounds are meant to be short. The shell of an argument is where you run to
Yes.
25 pages, as people seem to be always managing to do. But grounds are meant to be very succinct statements. A page or two is normally plenty. So could that point please be noted by those behind you?
Yes, we note the point, and thank you for and apologies for the
Okay, well, right, so we're ready to go, aren't we?
is that a person cannot be committed for contempt on an uncertain order, and where the order is insufficiently clear, the committal should not take place. The grounds in relation to clause 7 it is submitted is even starker, because this involves an economic tort which, with an agreement, a conspiracy, and there are overlaying intentions within clause 7 that a person is meant to understand when they look at that order. And so in relation to clause 7,
Laying out your stall, I'll just sit and listen, but if you actually wanted to say what's wrong with clause 7, we ought to go to
it
it.
probably would be helpful to go at this stage. Tab 24, if we go straight to clause 7 at page 365.
Paragraph, I think, technically. Yep.
And the committals were on 7.2. And 7 is with immediate effect the third defendant and each of them be restrained during traffic and with the intention of causing inconvenience and delay. Slow walking in
We
front...
don't need 2 or 3, do we? Were breaches found of 2 and 3?
Yes.
Oh, they were, I'm so
which
sorry.
was found on slow walking in front of vehicle with other...
Sorry, where are you reading from?
So after
Bottom.
7.3,
Yes, sir, thank you. Yep.
the additional...
Yep.
In total, there is at least 4 intentions there. The initial agreement and understanding of the intention of the other person as well as your own intention. And having the same intention, which is within 1 and 2, which is to actually block a highway and doing that with a view to slowing or stopping vehicles or pedestrian traffic. And also, and we're on to intention number 3, with the intention of causing inconvenience and delay. And then the intention number 4 is case intention of damaging the first claimant, which is Cuadrilla.
Sorry, I've only got 3 intentions, not 4. I'm sorry,
So-
can you just give me probably the first?
The first, we submit the intention from the agreement itself.
Oh, I
at
see.
7.
I see. All right.
So enter the agreement.
Yeah, okay, I understand. So you've got sort of 4 states of
We've
mind.
got 4, at least you could but 4 is a headline.
Well, that makes it quite hard to prove a breach. But in this case, it was proved.
And in
Well,
fact,
it means unclear when you're, but that doesn't quite answer. It may be difficult to prove a breach because you've got to prove you had all those intentions. But it was proved, as he says, and that's not being challenged.
but before,
So how does this so-called uncertainty actually bite to make the committal unlawful?
well, before the
Wrong.
breach, the person has to understand clearly what they can and can't do. So the protester in this case, and understand what they were doing, which was lawful, peaceful protest. The multiple intentions there, plus agreement, plus the added impeding activities by supply chain, that in itself is extremely confusing, even reading it out.
Why?
Yes,
Presumably you'd say no, because it wouldn't be wrong unless
But
it had various
yes,
intentions.
but it would have to identify a tort, an economic tort, by and you can see that by the unlawful acts or unlawful means.
But what is the prejudice to the protesters?
The
Are you suggesting, because my intention isn't, it may be to cause some inconvenience and delay, but I'm not actually intending to damage the first claimant, so
protest often includes blocking the highway and disrupting traffic, causing inconvenience, causing delay. There may well be usually a criminal trial if there's that they were also arrested for obstructing the highway for their activities for locking on in front of the Bellmouth in July 2018, and the magistrate subsequently found them not guilty, having considered reasonableness. And so the submission is that the reasonableness and the intention should not be at the point of preventing activity via an injunction, because
well,
what
reasonableness is a very different thing from intention.
well,
That's a value judgment, but whether you intend something is a question of fact.
or justification is within the civil context. You would still have a trial looking at whether there's justification for
But
the
none of
action.
these concepts appear in the order, reasonableness, justification. So I can't quite see where this is going. I take your point about intention, and that's what I thought this round of appeal was about. But you seem to be branching off into all sorts of other points, which are not in the ground, and don't arise in the wording of the order.
The intention is within. So the points there on intention. If I could just go to the Sunday Times authority, which is at tab 3, and then stick with clause 7, and then come back to clause 4. And so that is in the agreed bundle authorities, tab 3, and it's our skeleton at paragraph 30. And this case, the judgment itself begins at page 268, and it was the case of where the Sunday Times had began a series of articles concerning the use of the drug thalidomide and its effect on a number of pregnant women who were giving birth to deformed children. And one proposed article was to deal with the history of the testing, manufacturing of the drug, but an injunction was obtained restraining publication of the article on the ground the passage, forgive me, starts at paragraph 46, where they're considering whether the interference is prescribed by law, and the argument there was that the law of contempt was so uncertain and vague that it was not prescribed by law, that it was roughly, and the government argued it was roughly foreseeable. At paragraph 49, the court's opinion, the following two are the lines that flow from the expression.
Are you going to read out? Wouldn't it be easier for us to read the passage to ourselves?
If you wish to read the
Well,
passage yourself,
which
49.
just 49.
Paragraph 49, please.
Very well, thank you. Give us a moment. Yes. So what's the particular proposition you want to
The
get out of
proposition
that?
is that the clause 7 in particular is not adequately accessible to the citizen. It's not clear, and so the citizen does not know how to regulate their conduct. The protester does not know what is a protest and what is a breach of an order.
Well, is your argument that simply by including the concept of intention that makes the order unclear?
Yes.
Or is it that it's unclear because of the number of intentions that have to be proved, and where does what is the criterion?
It's a combination of various propositions. In this case, it's accepted that there are orders where there are intentions, and it's not a bright line that there can never be an intention within an injunction. However, it is preferable that there is not the use of an intention or a subjective element within an injunction.
Is that, I don't understand why that should be so.
Well, that
You're bound, the difficulty is all for the person bringing the committal proceedings against you. There's no difficulty. The one thing you will always know is what your intentions are. It may be difficult for the, in this case, Cuadrilla to prove it, though in fact they managed to. But I don't quite see why reference to uncertainty, to intention, is ipso facto, I'll start again, why reference to uncertainty, because it is, I'll try one more time, reference to intention, because it is subjective, creates an uncertainty for the person whose intention is in issue.
Because you can have an intention which is perfectly lawful, and so by creating within an injunction a presumption that a certain intention is going to be unlawful and therefore caught by the order, it is effectively putting the litigation the wrong way round.
It all depends what the intention is, but
I don't understand that point.
So, but in this case, which is with clause 7, there is not only it's unclear because not only is it dealing with only one intention, it's dealing with multiple intentions, but even with one intention, it's put within an agreement, and there has to be, in order to get an injunction, it has to be based on a tort, and so this is created to be an economic tort.
well, you're moving around from one proposition to another. I thought your proposition was that it was wrong to have a reference to intention because it was subjective. That I don't understand. But when I put that to you, you're moving away saying, well, the particular kind of intention is one which the person who reads the injunction wants to know what they can do and can't do, isn't easily able to understand. But that's nothing to do with being intention. It's to do with an overcomplicated order. or an overcomplicated concept?
Perhaps if we go, the 2 points do come together, and I'm sorry if I'm inappropriately moving from one to the other on foreseeability, because there are, effectively, to break them down, there's three issues here. Okay. There's the clarity on the foreseeability. So can the citizen...
Wait. I'm write this down. It's helpful. 3 issues. What is the first one?
Foreseeability. Can the citizen foresee
the consequence of their action?
The consequence of their action, whether their action is going to be lawful or unlawful.
Matrix foresee whether... Foresee is an odd word.
Not the consequence of their acts, but whether... Can they tell whether what they will do will be in breach of the order or not?
Yes.
Okay. So, if you don't mind, I wouldn't really use the word foreseeability for that. It's really about something different.
Well, the Sunday Times uses foresee to a degree that is reasonable.
Okay, well, if that's the sense in which it's being used,
that's
so be it.
paragraph
But the real point is the one my Lord just put to you. Can the citizen tell whether what they are proposing to do will be lawful or not? Will be a breach of the order or not? Yeah, that's your first point? Yeah.
That's the first point. The second point is the inclusion of intention within an order is undesirable.
So what's...
So the submission is there's no bright line, but it's undesirable.
Is that not just a part of your first submission?
They make
Makes it
together.
difficult, yes.
Can I call it A?
They blend together, yes.
They're undesirable.
Is that the reason why it's undesirable? Because it's hard to know what your intentions are, or is there any other reason why it's undesirable?
Because your intention, it's hard to know what your intentions are. They could change.
And you'll always know at any one point when you're doing something what your intentions are.
Or it could change very quickly.
Well, then,
this is
then the moment it changes, you'll know whether you're doing something lawful or not. If you think...
Well, there is a point, I suppose, that intention is a legal concept. And I think you have the point that what ordinary people might think of as intention is not necessarily what the law thinks of as intention.
Yes.
You might think, I suppose, then following up my Lord's point, that even if you foresee that what you're doing may cause inconvenience, if that isn't your motive for doing it, you may think to yourself, although it won't be the law, that's not what you're intending. It's a side effect, you might think, of what
it might be incidental.
Is that a...
Yes, it might be incidental, or you might have an intention to cause disruption, but that being within a context of peaceful protest, and therefore that being a situation where perhaps the second or third part of this is that it therefore would not be prescribed by law for you not to hold that intention to cause disruption, or to slow down traffic, or to cause traffic jams, because that would be you carrying out your lawful right to protest.
What would you think, sorry, what would you think the order was aimed at if you read it? I mean, if you're a protester, what do you think it stops you doing? If it's fine to lock yourself in the middle of the highway and block it?
It's aimed at direct action protest, which is by itself not unlawful.
Sorry, what do you think the order forbids you from doing?
It forbids from clause 7.
Yeah. What might you think, reading the order, it stops you from doing? If you're suggesting a reasonable reader might think that it doesn't forbid you from locking yourself to somebody else in the middle of the road for half an hour or for 4 hours.
Well, that in itself, if it was drafted in a way without an agreement with somebody else, without unlawful means, with inclusion of actual damage to a supply chain perhaps, then this would come within a tort. But what it is it's setting out, it is setting out a concept that is not, which would catch people who are not behaving unlawfully.
But surely the court has done that exercise. It has decided that if you do those things, then you are going beyond the right of peaceful protest. So you can't say, if I read the order, it's uncertain whether this will be peaceful protest or not, because the court has said it won't be peaceful protest, it will be unlawful. Then your only question is, all right, what is it says I can and can't do? That comes back to your earlier point, which I certainly understand. But if you're submitting that that is confusing because you don't know whether sometimes this will be lawful and sometimes it won't, because you may be able to rely on a defence of peaceful protest, that decision's already been taken for you by the court. And if you didn't like the decision, you could have appealed against it and said it goes too far.
Well, I accept that, but the position also is it still has to be an order that is prescribed by law.
Well, it has been prescribed by law by the court making it.
But it's been prescribed by law on, or if it does exist, is so unclear that nobody would understand what it actually means.
Well, I'm trying to pin you down. The second point I understand, and that's where
It was argued, but and this is where I appreciate you may consider I'm moving away from intention. The point is there on intention and lack of clarity, and the cases probably aren't particularly in dispute in relation to that. However, it's submitted that this should not also move away from looking at clause 7 itself, in that although it was granted by His Honour Judge Pelling, it was done so on law that actually doesn't frankly exist. It's based on an economic tort that does not exist.
There was no
And
appeal
so
against the injunction.
There's been no appeal against it. However, you've got a finding on a law which firstly is submitted to be unclear.
I'm quite confused. You were saying that conspiracy to injure doesn't exist.
The economic tort. So with Clark, I can take you to Clark and Lisle. So this is
just
an
before you do
unlawful
that,
act.
could you just show us the passage in your skeleton? I hadn't really picked up that this was going to be an argument. Where's the passage in your skeleton argument saying that there is no such tort?
It's not within the skeleton argument. It's within the. It's probably, if anything, it's taken from the respondent argument where they refer to it as an unlawful means tort.
This is
So
why
it's
your
taking
grounds
that
of
on.
appeal are important. We seem to be having two strands of argument coming out, neither of which I think, to be fair, is in your grounds. The first is we now hear that this is based on a tort that doesn't exist on the facts of this case. The second also seems to be that the grant of this injunction was itself in breach of the Human Rights Act and the Convention, but that is not a ground of appeal.
It's a matter that, in considering in the skeleton argument, so page 11 under Articles 10 and 11, looking at paragraph 39 and 40, obviously Articles 10 and 11 are protections.
Sorry,
Where
paragraphs
there's-
39 and 40 in your skeleton
In the
argument.
skeleton argument, which is
Yes.
tab 4.
Yes, but absolutely. And 39 is, as it were, a preface to 40, and 40 makes the point which I thought was your point, which is about certainty. And your point about certainty itself is because of the references to intention. I always thought what we were coming here to deal with was an argument that said this injunction was framed in a way which was so uncertain that it would be wrong to commit anyone for breach of it.
That is the argument.
Yeah, that's fine. I understand that, and you were helpfully at one point going, and I certainly don't want to stop you doing that. But I'm a bit uneasy about us going over into all sorts of points which come from nowhere, as far as I can see.
I will move back to the uncertainty.
Yes,
point.
well, that would be very helpful.
And so,
Thank
if
you.
I can take your lordships, please, to our skeleton argument at paragraph 27 and 28.
Yes.
And this was where, in '97, the Attorney General obtained interlocutory injunctions against David Shaler, the former, relating to certain work in the security services. As a result of his employment there, there was then an article published which included information restraint. The appeal went initially in the direction of the editor, that he was allowed to allowed to publish, and then the Attorney General on appeal, that appeal was upheld. And if I can take you to paragraphs, the terms of the order, it was Mr. Justice Hooper, was set out at paragraphs 35 and 36. This is the judgment of Lord Nichols. Doctrine injunction, so it's not a queer time-it injunction like the INEOS case one, but it's an interlocutory injunction, and the terms must be clear and certain. Must define precisely what acts are prohibited. A person should not be put at risk of being in contempt of court of an ambiguous prohibition, or a prohibition the scope of which is of the appellants were committed.
Yes.
An order expressed to restrain publication of confidential information disclosure risk damaging national security would be undesirable for this reason. That was in that case. And further down in paragraph 36, risk damaging national security, there may well be matters whose disclosure would attract diametrically opposite views. The Attorney General contending disclosure would risk damaging national security. Mr. Shaler contesting that disclosure would even arguably pose such a risk. An interlocutory order ought not to be drawn in terms where it's apparent that such a dispute may arise over its scope. So the dispute on a locking on is direct action peaceful protest.
Well, hang on. But where does the order refer to direct action peaceful protest?
It's
well, hang on.
unlawful acts.
Yes, but it says what the unlawful acts are. 7.1.
That's not an additional restriction. Maybe rather unfortunately worded.
Yes.
Yes, that's just a heading for the following things. So you have to look at 7.1 to 7.3 to see whether you can do them or not.
It's a heading. However, it's still unclear what the unlawful acts are. Is the unlawful act, if you look at 7.21, blocking with intention causing delay, or is it blocking with intention of causing inconvenience and delay? Is that which
well,
is
that's what it says, inconvenience and delay.
But what if
It might be difficult, as my lord said earlier, to get a conviction. But if you actually find, take a nice straightforward case, that emails which say, let's go and cause inconvenience and delay, then you'd be able to prove it.
to have grounded within the tort intention of damaging plus...
Oh, sorry, yes, but I was taking one step at
Yes,
a time. I was just dealing with
absolutely.
your inconvenience point.
Absolutely, I understand. But you would also then need within that intention of damaging Cuadrilla. What if someone was concerned with damaging a supply chain, considering that Cuadrilla's going to carry on fracking irrespective, but had an issue with Stobart, who was doing the delivery, and a person in the agreement came within causing inconvenience to Cuadrilla itself and damage there. Where does the unlawful act bite out of any of those scenarios?
Well, there seem to me to be two kinds of uncertainty different from the legal concept of intention. But, in principle, if you take advice, you'll be told that if you foresee and know that your act is going to have a certain effect, then you will be held to have intended it. Legitimately hold different opinions about it, but that kind of uncertainty isn't in this order, is it?
Well, I submit it is, because what's inconvenience? I mean, one person's inconvenience might be another person's usual waiting around. So what's delay?
Well,
How much
that's
delay?
different. That's not that. Those aren't concepts which involve some sort of political judgment, like national security. They're matters of degree, and there may be a band within which somebody could reasonably think that they're not causing inconvenience and delay. But by the time you've been there for long enough, then any reasonable person's going to recognise that the effect of what they're doing.
It concerns the word, but by doing that, that emphasises that these mens rea subjective elements that you find in criminal trials have been incorporated into a civil injunction, which obviously has to be grounded on a particular tort.
But standing back from it for a moment, looking at the reality, the whole point of locking yourself to somebody else in the middle of the road is to cause inconvenience and delay, isn't it? It's wishing to draw attention to your cause.
Amount of blocking, because
Well, that's something that be determined at the trial.
but there are lock-ons where it is for the publicity stunt, and in fact determined at trial. Yes, this happens in criminal cases all the time, where usually on the other side the prosecution is submitting that this was a publicity stunt. There was no necessity to act in this way, for example. But these are all very finely honed and very complex issues of mens rea, which should not find their way within a civil order, because it comes back to, and there certainly should not be a committal on an order which has got that amount of ambiguity to it, because as has been pointed out, interpretation, and so the order itself is not clear. The people approach the order, which are posted up on the railings around the site that was being fracked at that time, and they may consider, well,
It's effective, and so therefore it's impossible in your submission actually to prevent people blocking the route, the entranceway, for as long as they, because either the order will be too broad for the tort, or it will be too uncertain, and so it's impossible to have one. Is that the logic of the submission?
that is the tort. The area of civil law should focus on private trespass as it's something that is clear, and query whether it is simply too uncertain to try and tackle potential obstruction of a highway, and that should be the place of the criminal law.
So you are saying that you can't frame a civil injunction to prevent obstruction of the highway. Is that what you're saying? It's inherently too uncertain.
Yes, I wouldn't put it quite as high that you certainly couldn't. The submission is that this is obviously an attempt to put all sorts of elements within it, which has caused it to be uncertain. So this is one which is not clear. Now, whether you can formulate a tort in a civil order of blocking a highway itself, I would query in an economic tort, because this is the first time that there's been any enforcement of a clause of this type, because this type of conspiring for unlawful means, unlawful act, the Tiny Rowland Al-Fayed line of jurisprudence. And so the submission would be, no, you cannot formulate a tort for a supply chain as this is. You cannot formulate a tort against
accepting, let's accept, because I'm not challenging this, that it exists, but it's not really given the nature of the salt and the ingredients that you have to establish to
Absolutely, yes. And obviously the parties as well, because it's from the private injunction from Cuadrilla, it's obviously not from the local authority, which is the point you already have. So in this type, with these from a fracking corporation, the answer would be no. It would be a matter for the local authority if they wish to try and pursue an obstruction of the highway, which they do not. And in fact, there's some evidence of support had, in fact, not wanted the fracking. The local authority hadn't wanted the fracking in the first place because they were returned by the central government, and hence the local authority.
We're going rather a long way away from the...
I mean, this injunction, in fact...
Yes, it does. So I was... I went back to 7, and perhaps while we're at 7, we can have a look at 4, because there's similar issues with 4.
What's the basis, what form of nuisance is this based on?
Well...
Is it public nuisance?
It's public nuisance, blocking any part of the bell mouth at the site entrance with persons or things when done with a view to slowing down or stopping the traffic.
Just give me 1 moment of just
So
rereading it, yeah.
Yeah. Shall I?
Just give me a second. Yeah. Was it 4.1 that the breach was found of?
Yeah.
Yes.
So we needn't worry about 4.2 and 4.3, but then, as you say, at the end, there's the further intention words there. Yep.
Yes. Can I just double check on 4.2?
I don't recall there being any slow walking in this case, but I may be wrong. I thought the relevant breaches were...
Other findings that then...
didn't result in
yes,
weren't treated as...
which might, and again, the intention of traffic in general or pedestrian. The persons unknown is the other aspect of the lack of clarity, because it's not an injunction directed obviously at particular people where their behaviour is targeted, so that they can consider and they understand what type of behaviour it is that had led to those.
Sorry, what just tell me again, what's the submission here?
So the submission with this is also a persons unknown injunction.
Well, it obviously is a persons unknown injunction, but just looking at the ground, where is that?
Look at the legal certainty in the skeleton at paragraph.
If it is made against persons unknown, there's a whole lot of rules about when you can and can't do that. But that doesn't infect the language. Once you decide that a person covered by it has notice of it, then you're back just as if it was a named person, aren't you? I'm just not quite sure what the fact of it being persons unknown adds to the uncertainty.
Yes.
Does it add anything in this case?
I submit it adds this, is that where these orders have evolved from regulating the conduct of specified people, then inevitably within that specified person is brought to the attention of that particular person. They are immediately focusing their minds on what particular activity they are prohibited from doing. When it is against persons unknown...
But surely, I don't even know whether it was an issue.
Just take to Hampshire Ways.
Yes.
And so that is at tab 7. It was asked if environmental protesters had trespassed on such sites, and an application was made by the companies for an injunction restraining persons from entering or remaining without the company's consent on it could not be identified in advance. Such an order was required as the police were largely powerless to prevent such occurrences. And paragraph 9, so the judgment of the Vice-Chancellor, and looking at paragraph 9, where he sets out that the 2 points are that it seems to me to be wrong that the description of the defendant should involve a similar legal conclusion, such as it's implicit in the word trespass. Similarly, it seems to me undesirable to use a description such as intending to trespass, because that depends on the subjective intention of the individual, which is not necessarily known to the outside world, and in particular the claimants, and is susceptible of change.
I mean, he's focusing really there on what's a problem for the claimants.
There is a focus, it can be a problem for claimants.
Well, that,
However,
not only it can be, saying that that is why it's undesirable.
well, it's undesirable to use a description such as intending.
Because
It's not necessarily known to the outside world, in particular to the claimants, and is susceptible of change. However, the point is it's still undesirable to use it, whatever the actual motivation is. It's also undesirable from the point of view of the appellants or claimants.
But this case is concerned, it's not concerned with the terms of the injunction, it's concerned with the way in which the persons unknown are described. I mean, I should have thought...
Anticipated protests against fracking operations might cross the boundary between legitimate and illegitimate activity, and therefore they sought the injunction to restrain sites. I appreciate this court is very familiar with this case. The appeal was from Mr. Justice Morgan, and the appeal was allowed, and Lord Justice Longmore protested against. The material aspects of INEOS and of the material aspects of the injunction.
They can't be quite the same, because in INEOS it had terms like unreasonably and without lawful authority or excuse. Part of one of the most serious problems, which isn't in this order.
It's not in that. It had, I guess in relation to INEOS, if I can then go to paragraph 31. So 30 and 31 are looking at persons unknown, and there's no conceptual or legal prohibition. However, a court at 31 should be inherently cautious about granting injunctions against unknown persons, since the reach of the injunction is necessarily difficult to assess in advance. The submission is that in assessing reach is relevant to uncertain damage, but they're not within that, and they consider that those they're agreeing with have a similar intention, but maybe those people don't. It all becomes extremely unclear. And I will come to the judgment of the lower court, because the judgment itself was a very short finding.
so that we're putting INEOS away now, are we?
I'm going to stick to INEOS, but just to develop the point that the judgment itself was a very short finding, that there could be no other intention but, and this is difficulty.
The judgment in this case? Sorry.
In this case, yes. But if I just go through the other paragraphs of INEOS, if we could take your attention to 34. Now, this is where it's looking at a career timer injunction, but the part 5 is relevant.
Can I just, at this point, maybe the second time you've referred to this being a career timid injunction, and that seems to be a point that the judge below, and I think perhaps Mr. Roscoe, has in mind, but I don't really see that this is, that the injunction in this case seems to me to be in large part a career timid.
If it's not, the ratio of this decision, these paragraphs still apply. Exactly the same to
quite so,
interim.
yes. Right.
Interim injunction.
Yeah. So you're not seeking to make some distinction been INEOS in this case,
No.
on the grounds that it was creative there, but not here.
No.
No,
No.
thank you.
And the paragraph 34, subsection 5 there, where the terms of the injunction must be sufficiently clear and precise as to enable persons potentially affected to know what they must not do.
That's, am I right, that of the 6 requirements, that is the only one that you say is violated by this injunction? The others were satisfied?
4, that the injunction must correspond to the threatened tort.
In which case, with the intention of damaging the first claim.
Well, with Clark and Linson on unlawful business.
And you're right that in order to sue for damage, you've got to be able to point to damage, but you can certainly get an injunction to restrain the proposed commission of the tort, in which case ex hypothesi there will be no damage,
You'll stop
unless
it.
we're left in breach of the injunction.
Yes, that would be a different type of economic tort, however,
it
that would be an
no,
intention.
forgive me, it wouldn't at all, would it?
If I can just go to Clark and Linson
Right.
on it. And so it's in the second authorities.
There's no problem about that, is there? I mean, you'd have to show, satisfy the court that there was likely to be, or whatever the test is, damage if the conspiracy is given effect to.
Yes. Can I ask the court's comments just to take it?
Yes.
The respondents did refer to this in the court below, so it's not taken by surprise. And this is where the Claimant Bank was granted a worldwide freezing order against the first defendant in support of proceedings, which it brought to recover large sums.
Same time. Okay, carry on.
I was after stolen money. I was going to
Yep.
The defendant breached that order by dealing with frozen assets, fleeing the UK for France, and then moving on to the second defendant applied inter alia for an order setting aside the claim form on grounds that contempt of court could not constitute unlawful means for the purposes of the tort, and that he should in any event be sued in Switzerland. The bank resisted the application on the ground that the English courts has special jurisdiction. The judge concluded that the bank had a good arguable case that the second defendant had committed the tort of conspiracy to injure by unlawful means, and then the second defendant appealed and the bank cross-appealed. The Court of Appeal dismissed the appeal and allowed the cross-appeal. If I can go, has to be grounded in damage.
Oh, but
Yes,
sorry,
Yes,
sorry. That's what you showed us from Clark and Lindsell, and there's no dispute about it.
Right.
But my Lord's point to you was
Intention.
that for an injunction, the whole point about an injunction is to stop it happening. So, by definition, you may not be able to show damage at the moment you get the injunction, but your point is that if the person isn't enjoined, they will go on and give effect to the conspiracy which will cause damage. To me, I'm afraid that seems obviously right, but
Your point is it that the injunction stops them doing something which doesn't necessarily cause damage and which therefore may not be a tort?
Yes. And if I can just flag up,
Stopping them doing something which may or may not actually be a tort.
that's the point.
right, thank you.
Thank you for
I've got that.
clearing much more clearly than I was trying to. And that's what that case sets out, referring back to taking that one.
So can we just look at the terms of the injunction, see how that applies to the wording?
Yes,
This is a para 7 point then.
it is.
Intention of, to paraphrase, obstructing the supply chain. Won't that cause actual damage?
To the claimant,
Yes.
not necessarily, no.
It has to be economic damage. It's not just inconvenience and
Yes.
delay. Won't be a breach. Won't be a tort. That's why they need to have the last bit, at the very least, below 7.3. Because in order to succeed in a tort claim for damages, you'd have to prove the economic quantifiable loss that you've suffered.
Yes, and there was, and I would also submit and against here where the public, those who are protecting the interests of public protest, whether they would come in on actually having an economic interest that could be restrained by a tort of this kind, an economic tort.
I mean, is part of your argument this, that the nature of this tort is it's protecting people against economic loss?
Yes, absolutely.
If you have an injunction to stop it, you're elevating what's meant to be really all about financial loss and damage
Yes.
into something that somebody can be sent to prison if they don't do certain things.
Yes.
And that is really taking this tort beyond its proper parameters
Yes.
and going into the sphere of what is really properly regulated only by the criminal law.
Absolutely. I'm very grateful. It's been stretched far beyond its purpose, and as far as there's been a committal on such a clause.
Well, a committal obviously brings it into but the real question is whether such an order should be made in the first place. I'm just trying to think back to, I ought to have this at my fingertips. Employment cases. I mean, a lot of the law in this was developed in
Trade union.
Yes.
Yes. And I don't think you've given any of those authorities.
I haven't.
But I mean, I was thinking of Heaton's Transport, and I mean, the trouble is with the employment cases, they tend to go off on questions about the extent of the protection.
Yes.
But some of the early cases were undoubtedly about whether there was a tort committed in the first place.
But were there injunctions granted on the basis of unlawful means to preempt it?
I've got a feeling there were, but I'd have to look.
Or
perhaps someone can look over lunch.
We haven't been able to
The
find
names
it.
that are in my mind are I may be remembering them wrong. Transport, Stratford and Lindley.
Yes, I've looked at all of those.
Oh, have you?
Yes.
Well, what were they about? If they weren't about injunctions.
We have a look. They wouldn't. I'm saying I've looked at them. I didn't consider them as going against the argument. That so I will go back to them. But the line of authorities that I went through was the tiny Rowlands against Al Fayed, which.
Yes, but you're essentially trying to prove a negative. You're asserting a negative. You're saying no such order has been made before. Actually, not before this case, but before INEOS.
Before
and you may be right about that, but
it failed in INEOS anyway.
and it failed in INEOS.
Yes, exactly.
Which is very significant.
Yes.
Well, I mean, paragraph 7 in the light of INEOS is in a form that should not be made.
Yes.
But why does it follow from that those who act in breach of it are not in contempt of court?
Well, the submission in relation to that is it should not have been made because it was not clear enough.
Well, I think, isn't your more realistic submission that it was a contempt of court, but it's not appropriate to punish it with committal to prison if it's a breach of an order that ought not properly to have been made?
Yes, so a finding of a breach, I'll adopt that gratefully.
In the alternative.
In the alternative. Adopt that in the alternative. And in addition, the clause is so unclear. It goes back to
If someone is clearly within it, so they clearly did breach it, however unclear in general terms the order is, why are they not in contempt of court in breaching that order?
breaching an order that should not have been made in the first place.
Correct.
Because it comes back to why should the order not have been made in the first place.
But that's no, I mean...
That isn't a defence.
I mean, you're familiar with M and the Home Office?
Yes.
Yes. Well, that wasn't simply an order that should not have been made. That was an order which was contrary to, I think, the relevant statutory provision. But because the High Court was a court of unlimited jurisdiction, the order was binding until set aside.
I accept that
And that's a starker case than this case, and yet the then Home Secretary was in contempt of court.
but that didn't involve Article 10, Article 11 protest rights
So-
in addition. So whenever there's an interference by a public authority, then
But none of these give you an excuse for breaking the order, do they? I mean, just in principle. They might give you a mitigation, why it shouldn't result in committal,
Shouldn't
or
result
they
in-
might give you a basis for appealing against the order or seeking to get it set aside. But they don't say well, it wasn't a contempt, deliberate breach of the order. There's no defence to contempt on the basis the order was wrongly made in the first place. Otherwise, it's always up for grabs again on the contempt hearing.
I accept that it can always be up for grabs if there was going to be those submissions on this order is not clear enough, even if it's subsequently found to be unlawfully made. Of course, those cases are clear. However, the submission here is that this is a different type of case. It can be distinguished because it is against persons unknown, and it has these layers of intent within there. It has a underpinning.
Well, we're coming back now to
capital.
your,
So
the points you've already
coming back
made.
to the points I've already made in relation to this, that the finding therefore should not have been made against these particular peaceful protests, and it is very significant that the Court of Appeal is still binding, obviously, in any a very recent case. If I can just finish off, leaving that, I think we're very grateful for the assistance on the economic talk point, but the House of Lords, it's Lord Sumption in particular in the House of Lords.
Sorry, we're going back to JSC, are we?
JSC.
Give me a moment, let's get it back again.
This was the agreement.
JSC.
The additional
the
one. Yeah.
incinerators.
Sorry. Sorry. No,
Sorry, we're at cross purposes.
Which case are we
I
looking
thought
at?
you said JSC.
JSC.
Yeah, it's not about incinerators, is it? Or is it?
No, it's about Mr.
about
Abliazzo,
that's
who was fraudulently
that's my fault. Yes, we
defrauded
moved
of
away.
Russian bank.
Yes, it's a freezing.
So are we
multi-billion.
JSC? Yes.
Yes.
So Lord Sumption.
You can always see the kind of case it is when it says JSC BTA Bank.
Yes.
And it's Abliazzo of number 14.
Yes, yes, I had one
Yeah.
of those.
So are you looking at?
So
Where
I
are we looking at?
take you to paragraph 11.
Well, you've taken us to that already.
And then I can take you on. The following paragraphs refer back to total network on intention, and particularly at H, and looking at lawful and unlawful means.
Sorry, where are you?
Sorry,
just
I
above-
speaking for myself, I think I just need quickly to read the whole of 12 and 13.
Yes.
If there's
You want us to look at 12 and 13?
Please.
Yes.
So what?
So, drawing attention to the analysis of intention within the conspiracy, and
Well-
particularly the last lines on the conspiracy may be directed against the claimant, notwithstanding its predominant purpose is not to injure him.
Sorry, last line of
on
what?
H on 30.
So the last line of
lines.
page 1135.
Yeah. predominant purpose is not to injure him, but to further some commercial objective of the defendant.
Yes.
And then it carries on over the
Well,
page.
we've read that, but I mean slow. How does this help the point you're making?
On the, as well in this judgment, this also makes it clear.
Sorry, we didn't read. Well, I didn't read 14.
So
we don't just read 14.
14, yes, over the
I
page.
mean, this just tells us what the ingredients of the tort are, doesn't it?
It goes through the
We know
ingredients of
that.
the tort, which you may already have, because it was set out in Carpenter's.
Well, do you or don't you want us to read 14?
You can read
If it is simply to tell us, as you say, the ingredients of the tort, as my lord says, we do know that.
I think Lonro, so 14 does set out the ingredients of the tort, but Lord Mance is always referred to. We'll just go back to what he said in total network, which is in paragraph 14, which is part of the point that.
Well, then look, I think rather let's just read paragraph 14,
Yes.
then you tell us what you want to get out of it. Yeah.
The points from this is that at the start of paragraph 14, the harm, looking at the intention, the harm cannot be purely incidental. So this is relevant to clause 7 concerning supply chains. If there's economic loss caused to a supply chain because of a delay in delivery, that may well be incidental to the claimant, or the respondent here, Cuadrilla.
Yes.
And so it's going again to the uncertainty around intention, having that within, trying
Hang
to
on,
shoehorn
it
this
doesn't
forward.
clause 7, para 7,
Yes.
actually require an intention to cause damage
To the first
to,
case.
To the first claim.
Cuadrilla. So all these subtleties are, that's the form the damage takes, but the intention is to do the damage to the claimant.
To the claimant covered, if they then take their peaceful protest, which is a lock-on, which is the actors of this particular case. And the House of Lords case that I've been referring to, the JSC Bank, really goes over this, and paragraph 17 is again coming back
Sorry,
to.
I keep putting it away.
I don't think we're getting anything out of this case
Well,
at the moment.
I can leave it, but paragraph 16 is the other one on unlawful means, looking at what unlawful
You don't
means
need to
means.
persuade us that the law of various forms of conspiracy is quite subtle and difficult, and including because of the concepts of intention which it involves.
I agree. And are too wide and insufficiently clear.
So, but hang on, is 39 about the same?
The same issues on looking at the supply chain clause.
Okay,
which
well
is
let me just reread 39. We really need to read on, don't we? How much would you like us to read?
Up to 42.
My lords will be even more familiar with this than I am, but it's worth rereading. an awful lot of the objections that have been made in para 40 don't apply to the order here. Most of them don't.
However, there is a theme running through this that, I mean, if you take the last sentence of 42, the citizen's right of protest is not to be diminished by advanced fear of committal, except in the clearest of cases, of which trespass is perhaps the best example, where I think he is indicating that the nature of this tort is not one that lends itself readily, at least, to injunctive relief.
Yes. It has a chilling effect upon protest. And yes,
Okay.
although we also will submit that it is very similar. The slow walking, for example, the obstruction of the highway, the agreement to, in fact, this case followed that order that was made by Mr. Justice Morgan. They are the same in material respects as was
Well,
accepted.
not entirely, because
To tab 8 in the core bundle.
Sorry, paragraph
29.
29.
Please. Page 138. And this was the submission that was referred to earlier concerning the quid timid injunction that the respondents
First sentence. Something gone wrong with the first sentence.
it was submitted by Mr. Roscoe on behalf of Cuadrilla.
But nothing in the Court of Appeal judgment was relevant to
relevant.
any application.
Involve a quid timid
Okay.
injunction. He relied on Mr. David Hall, his deputy judge.
Sorry.
Perhaps if I take you back, it's my fault.
Sorry.
Well, it's just a matter of English. Might it mean any of the applications to commit?
It was the applications to commit, yes.
Yes, okay. Yeah, I see. So it shouldn't, that's how we should.
and he was submitting that it didn't involve a queer terminate injunction, which
The judge at paragraph 30 thought it went too far.
Oh, I see. Yes, okay, that was a submission. Yes, and my judge can't.
Sorry, what are you asking us to read?
So paragraph 30,
Yeah, I'm drifting.
that it made it difficult for the claimant for Cuadrilla and was not an issue concerning whether the actual order itself was clear or not. And we submit that that is not a correct interpretation of INEOS, and that the inclusion of these very complex concepts of intention and agreement, such as we've been through, should not be within an order because it makes it too uncertain. And it's not a matter of finding a breach and then committing on it and then considering mens rea at that stage. It should be considered at the stage of the committal itself and should not be committed on an unclear, uncertain order. And what he's done is he's followed the submissions of Cuadrilla that this is only relevant in fact to enforcement and has no relevance to certainty when looking at the committal itself. Carrying on, if I can invite you please to read clause paragraph 34, going over the page to 35. This looks at clause 4 in particular. very clear there, he completely rejects that.
In this case, you are addressing your first ground of appeal here.
On the uncertainty.
I mean, so I think we ought. I mean, I don't think we ought to. Personally, I don't think we should look at penalty till you've told us everything about rounds 1 and 2, because otherwise we will get at least I will get very confused. So, I mean, what my lord is saying, I think, is that this is a point that may be held over to when you get appeal on penalty.
What I'm saying is that I think ground 1 properly only goes to penalty. Because given that you accept that there was a breach of the order, there is liability. But your argument is that you shouldn't be committed to prison on the strength of an order that ought not to have been made, even though you were in fact in breach of it. I may be wrong. Maybe you're trying to argue that somehow it gives you a defence on liability, but you haven't yet identified how that's consistent with the law.
Yes, I've gone as far as I can on liability and certainty and lack of certainty, and the findings, the order was from the court. The only submission I made in relation to that, and I still make it, is whether when an order is made from a court, which is based on, in our submission, a tort, peaceful protest, and protected by Articles 10 and 11. So those protections come in whenever there's an interference by the public authority, and the interference by the order. So
even if the court's made an order, your arguments have been taken into account and accepted or rejected, you haven't appealed, you can have them, as it were, when it comes to contempt, and this time you might hope to persuade the court that because the order ought not to be made after all, you didn't actually contempt of court by deliberately breaching it.
Well, it might be that the order was so unclear that it's accepted there wasn't an appeal on the order itself, and a decision was made to go back to the court after INEOS to apply to vary.
To address the terms of the order.
Yes.
So is your argument really this, that it is open to persons in that position to say that it would be a breach of their convention rights to be committed for contempt for acting in breach of an order which itself breached their convention rights? Now, my lord's point, if they had been the defendants before the court when the original order was made, then of course they should have been making all those arguments then.
Yes.
But your clients today were not in that position. They were at that point persons unknown, who necessarily didn't have an involvement in or know about the making of this order. Is that?
Yes, absolutely.
But what I don't understand from all this is that I don't see from your grounds of appeal that you're attacking the original injunction on the grounds that it breached the convention rights of the persons unknown, which would have been, there'd be a full-scale attack, that it got the balance between the claimant's convention rights, of course they have convention rights, and the person's unknown convention rights wrong, such that the order was itself in breach of the defendant's convention rights. I don't see that, because it's all about the clarity of the order and so on, which is, in a sense, an order of detail, a long way down the scale from getting the balance wrong and as regards convention. That's just not an attack made.
The convention.
But it then says in paragraph 8 that it made an error of law reaching findings of contempt, which is a different point. There is no clear distinction between the two.
I mean, I suppose what's slightly unusual in this case, typically, you would have a finding of what the facts were, whether the order had been breached, and a decision whether to commit in a single hearing.
Yes.
There may be cases where and this was obviously one, where it was thought sensible to split them out. But a finding of breach is only a means to the ultimate decision, which is a decision whether to commit.
Yes, there were, in this case, there were two other findings of breaches which didn't then inform a decision to commit.
I still can't understand the legal basis on which you're claiming that there wasn't a deliberate breach of the order amounting to a contempt in this case. Unless you're saying that somebody who wasn't a party to the original injunction is somehow in a different position, even though he didn't apply when he knew about it, to bury it or set it aside. Or unless you're saying that where it infringes the Human Rights Act, that takes it differently from an order that is ultra vires for some other reason. There's no clear legal basis for your submission if you are going that far.
Yes, there's perhaps the lack of a clear legal basis is in part because this type of order prior to the INEOS case has not been used in cases of peaceful protest beyond the simple.
That's not a reason why you don't have a clear legal basis for challenging.
Well, I accept that.
What is the principle?
So the principle is that firstly it's persons unknown, so the appellants were not a category where the order was directed.
Case Cambridge or whatever it is, where the Master of the Rolls, Lord Clark, said that what you've got to do in that case is go to court when you do become a person known and challenge it, and you can't just wait till you've breached the order and then say, well, that meant, and then say, well, I wasn't in breach of it after all because you somehow the fact it shouldn't have been made means I didn't breach it.
The point on that is simply on the facts of this, that it was such a short time between the actual making of the order and the breach that.
So there's a different rule as to whether you can challenge the order according to the length of time, is there?
No, it's considering the context of the case itself as to why persons unknown were not immediately seeking legal advice on an order where they were not specifically identified, and also an order which is directed at peaceful protest with all those issues within clause 7 and clause 4 that we've identified.
You seem to be making it up as you go along, Miss Primolo.
Well, I'm trying to address the points because it is a novel point, and I'm not making up as I go along. It's grounded on Article 2 that earlier, and
But,
so
I mean, you see, even if you were to say that let's say not so much a committal, but a finding of breach of an order was itself a contravention of your convention rights because the original order struck the wrong balance, you'd then be asking this question, wouldn't you, whether a finding of breach in those circumstances was justifiable because your clients had deliberately breached a court order. So you get a different balancing exercise having to be addressed at that stage than the democratic society in court orders being obeyed. So the trouble with all this, I'm afraid, Mr. Primlow, is that it simply doesn't feature, certainly in your grounds of appeal and not really in your skeleton, where we're discussing and so on concepts and ideas that have formed no part of the case you've put in writing to this court.
I can't take it any further in that respect, and I appreciate the points that made, and it really is going back to relying on convention rights, and part of the reason a peaceful protest right, that there then is that balancing exercise that is
But all
is
that occurs at the point which we haven't yet reached, which is the sanction, or indeed whether to make the committal.
It might be that it can't take any bill there in relation to, because of the type of this order, and for June 2019. That the respondents intended to slow traffic. There was absolutely no reason for doing what they did other than to achieve that purpose. All the respondents said they intended to protest.
Well, you don't challenge any of these findings, so.
It's not challenged, but
No.
it is relevant in our submission to how this case was approached, and it's relevant to considering the complexity of the intention within 4 and 7, in that when the submission is put forward that they are only relevant to enforcement, we can see how enforcement is dealt with, how intention is dealt with when looking at enforcement, in that it's dealt with, it potentially can be dealt with in a very dismissive way, that has to be the intention, and there's no consideration of how protesters actually operate. And
Well,
what
if you're not challenging the conclusion on the basis that it doesn't get you anywhere.
It's not one of the grounds on the conclusion. And paragraph 45 as well.
If you were saying that meant he shouldn't have found it proved on the criminal standard of proof, that might be relevant, but you're not.
The sanction on the 3rd of September.
Yeah.
And that is at tab 10.
Yeah.
And Judge Pelling deals with INEOS in paragraph 9, and deals with INEOS, the paragraphs that we've gone to from paragraph 39 to 42.
Well, this is on the variation bit, isn't it?
It's on the variant and should of course be adopted. I do not accept that including the concept in order to limit the scope of an otherwise sufficiently clear and precise order needs to become unclear or imprecise. That's part of the complaint. And then he then turns at paragraph 13, he now looks at paragraph 4 of the order. And the finding over the page, at page 170, at the last 3 lines, it was submitted that if it was adopted in a protest case with the intention aspect, that it would have a chilling effect on protests and ought not to be permitted. I do not accept that, because the acts, the orders seek to restrain are not the core of Article 10 and Article 11.
This part of the judgment is not dealing with the committal orders at all. It's dealing with the bit that's not live in front of us. Now, you may be going to say, but you haven't said yet, and you make it clear, that in some way the one feeds into the other. But
11 rights are not concerned, they are not, this here is not a core protest case, because it's direct action protest.
And where does he say this in the penalty bit of his?
Well, that's his approach on Article 10, Article 11. On the penalty part, if we go through to he reiterates the partway through paragraph 25.
Yeah, okay, well that's helpful. So what you're saying is that the point starting secondly in paragraph 25
Yes.
feeds back into the passage you were just showing us.
Yes.
Okay. It's just
On the variation, I can just double check on that. If I yes, the appellants did apply in April to discharge 4 and 7,
Yeah.
which was resisted.
yes.
And
That was
then
immediately following INEOS, effectively.
immediately following INEOS.
Yes, that's what I
Yes. So
understand.
and then the respondent subsequently have made that application
Okay,
just
okay.
before this appeal.
Okay.
But there was no judgment on the application, your plan's application to discharge paragraphs 4 and 7 or
Well, isn't that
was
what?
there?
Isn't that?
Is that what?
That's the variation.
That's
That's the
yes.
I see.
This
So,
is
oh,
the-
I see.
This is the
That's
3rd
your
September. So
variation.
this is the
Yes,
variation.
yes.
Yes, I see. Sorry. Yes, right. Sorry.
I see, yes, I had not, I thought it
Yes.
was the respondent's
So did
variation.
I. But anyway, now
It's the
with it now.
appellants.
Right. Fine.
So I mean,
I see, so that is the relevance of what you were showing us earlier is you say the judge was wrong. Do you not to, in effect, not to discharge
Not
the
to
injunction?
discharge
Yeah,
the
it,
prospectively?
exactly,
Yes.
it plugs in to the arguments we've been having earlier.
Yeah.
Because even though you now accept you can't challenge the findings of breach, your pleaded position is that in deciding whether to commit for those breaches, it was relevant that the order was one that shouldn't have been made at all,
Yes.
or should have been varied so as to be unmade.
Yes. So to be varied so that it didn't.
Yeah, well, that's how I understood you were
Yes.
putting it, but I just think it needs to be knitted together.
Yes, no, absolutely. So there's been a number of moving parts in relation to this, and so that was rejected, and then the sanction aspect was turned to looking at sentencing guidelines from paragraph 27 onwards. But nowhere within this, other than referring back to what the judge considered was how we should concern Article 10, Article 11 rights. They are
Away the line of argument that you are now trying to advance in front of us, and that's why I certainly realised that when your dropping of the variation appeal didn't mean that none of the issues that would have been part of it might not still arise. I've got a double negative in there, but bits of it still survive in a different way.
They still survive, and they're still
Relevant to penalty.
relevant and interlocked.
And can I just be clear about this? When we say relevant, we're slipping around penalty, sanction, committal. The truth is, when there is a finding of a breach of the order, the only sanction that is provided for is committal. It is true it can be suspended, and it is true, obviously, that committal can be for the length of committal can vary. But you're really saying,
Yes.
but no sanction or penalty. No doubt you have a fallback position. We're not even sure
That's-
you don't actually have a fallback position because the sentences were in fact fairly short. That they could have been even shorter. So it's all or nothing on the point of principle.
Yes,
Yeah.
absolutely.
Okay.
Let me just There was success on 4 and 7 in that intention was removed and it was replaced with effect.
I thought the respondent wanted that. Is that wrong?
That was what the respondent wanted in. Yes.
Yeah, so they had success, but you didn't.
Well, it was your
success.
it was your.
Yeah.
This is what I understood the position to be. It was your application in the light of INEOS.
Yes, to discharge.
Respondents realistically accepted that in the light of INEOS there would have to be some variation.
I see.
And the debate was whether it should be that they should go all together, or whether they could be varied to some lesser extent, in particular by replacing intention with effect.
Yes.
Have I got that right?
Yes, they didn't accept that intention was an issue, and it was you can see that in the judgment. But it was the appellants were successful in that.
I see.
In part, in that it was varied.
I see.
And
Even though not in a way that would.
but not in a way where it's, and hence there was the permission to appeal the variation order
Right.
Yeah.
indicated.
But none of this mattered because the actual order of which the breach was raised to had the word intention in it.
Yes,
Yeah.
absolutely. And
Well, except it would have mattered if it had cut away.
he considered it might make it clearer to vary, and he didn't address at all the multiple intentions on the conspiracy. So that remained with effect, substituting intention on 4 and 7. The other variation, which I haven't come on to, is on clause 2, and that was the demarcation of the line, which if you crossed over would result in trespass. And he varied that. So if we go back to clause 2, there was a finding of a breach of that, but not a committal, so no sanction on that for Justice Lawrie. And that was because it was an aerial the boundary was drawn by land registry maps.
Are you pursuing ground 2? I mean, it doesn't actually challenge anything that the judge ordered at all.
It challenges the breach.
Well,
is
which
where-
isn't an order.
which is-
Not an order of the court.
I don't, yes.
And
I
it
don't
didn't
have-
affect his order because he found it was a breach that didn't justify a committal.
Yes, that's,
So it's a complete waste of time, isn't it,
That's-
ground 2?
yes, I have ground 2 within there in order to point out the lack of clarity overall with the order, but I'm not taking it on in itself any further in relation to, but that was the other aspect that was varied in that the blue line was able to be drawn, so it was then became clear.
Well, since the judge found she was a metre within, then it was pretty irrelevant anyway.
Well, it goes back to the
Well, now we know it's not.
No, yeah, I went to Ray.
carbon boards
Yeah.
on
Yeah, okay.
the Article 10, Article 11, which were not applied on the sanction. If I can take you to, again, the same judgment at paragraph, in one of the paragraphs he basically says, forgive me, I just need to find it. He says that, yes, paragraph 25, there he's saying that proportionality does not apply when considering committal and sanction because it's already been taken into account when the injunction was made, and we say that is clearly wrong.
What is clearly wrong?
That proportionality does not apply
Yes, great.
at committal.
That's really your principal point, isn't it?
On
this
sanction,
part of it, on
yes.
sanction.
And this was also the argument from the respondent that the judge adopted, that proportionality did not apply. And
I'm sorry, by the way, I'm wrong, aren't I? He could have fined you when I was
Yes,
doing it.
yes, he could have.
oh, you could find, yes. Sorry, I didn't hear that.
Clearly, your position, if prison centre, if
Confine,
no, what I'm now coming to, I'm just clearing the ground.
yes. And part of the argument in relation to that is that
But so you obviously you had a series of cases, but one of your cases was.
I'm not sure you actually set out what you say the approach on appeal should be to his presumably manifestly excessive or something
Yes.
equivalent to a criminal. We don't just interfere because we might not have come up with the same sentence.
course patience too much. We are in agreement that the test is obviously wrong in principle, but also manifestly excessive outside, which I will have to.
Come back to
Mr. Roscoe may know the answer.
Yeah.
It's the Liverpool Victoria insurance case, but I'll find the record.
Maybe we can have that after
Ashraf.
lunch. Let's just have effectively covered most of the ground, but they will be.
I probably will be no more than 20 minutes or 15 minutes back on some of the cases as well. Margaret Jones, Alan Jones, and
Okay.
Roberts, the latest Court of Appeal case.
You haven't actually orally addressed us on your really ground 3, because your point there is that the judge failed to give proper regard to the approach the criminal courts take when sentencing protesters for peaceful protest. Isn't that the? That's the. You deal with it fully in your
It's
skeleton,
the skeleton.
so I'm not saying you want to repeat
Yes, I was going
that,
to-
but you haven't
Yes, so I
addressed
was
us
going
orally
to
on
refer
that.
to the skeleton on the sentencing
On that
guidelines.
side,
There's no
yes.
dispute they should be read across, but also on, as these are peaceful protesters, to
Yes.
go to that particular